So there's a lot in this 50-page document, this complaint from Alvin Bragg, for the judge to chew on. But the most interesting part of the case brought by Alvin Bragg today is what it tells us about the real motive behind Jim Jordan's investigation. Bragg's lawsuit suggests that the reason Chairman Jordan is doing all of this isn't just to undermine that Manhattan DA or test the bounds of the Constitution, but to get a good look at the evidence against Donald Trump in order to feed that evidence, that information, back to Donald Trump. Bragg accuses Jordan of attempting to seek confidential investigative material from Bragg's investigation. According to the lawsuit, Congressman Jordan has requested all documents and communications between or among the New York County DA's office and the U.S. Department of Justice or other federal law enforcement agencies referring or relating to your office's investigation of President Donald Trump, which seems designed to sweep up as much information about the case against Donald Trump as possible. And remember those two prosecutors who resigned in protest from Bragg's office last year? Their names were Mark Pomerantz and Carey Dunn. They had been working on an earlier, broader investigation into Trump under Bragg's predecessor, former Manhattan DA Cy Vance. And like I said, their reason for quitting was that Alvin Bragg wasn't allegedly being aggressive enough in bringing that larger fraud case against Donald Trump. Which means that Dunn and Pomerantz probably know a lot about the evidence the state has amassed against Donald Trump. And Jim Jordan seems fairly obsessed with getting documents from Dunn and Pomerantz. Last week, Mr. Jordan subpoenaed Mr. Pomerantz to come and testify before his committee about the investigation. Jordan has also asked DA Bragg to turn over all documents and communications sent or received by former employees Carey Dunn and Mark Pomerantz referring or relating to President Donald Trump. Again, that is probably a whole lot of important and really relevant stuff, especially if you're Donald Trump. Bragg's lawsuit also notes that Jordan is also seeking testimony from lawyers currently inside the Manhattan DA's office, lawyers who presumably have up-to-date information on the case against Donald Trump, lawyers who stepped in when Dunn and Pomerantz stepped out. So, yes, this is a House investigation, but who is really calling the shots here? Whose interest is actually at the heart of all this? The DA would seem to have some ideas on that front. The lawsuit cites reporting from CNN that shows Trump is in constant contact with certain members of Congress. Congressman Jordan himself speaks regularly with the former president. And then it quotes Alvin Bragg saying this about Jim Jordan and two of his fellow Republican House chairmen. Based on the chairman's reportedly close collaboration with Mr. Trump in attacking this office and the grand jury process, it appears the chairmen are acting more like a criminal defense counsel, trying to gather evidence for a client, than a legislative body seeking to achieve a legitimate legislative objective. Joining us now is Harry Sandak, former assistant U.S. attorney for the Southern District of New York. Harry, thanks for joining me. And I am eager to get your thoughts on this because there is a lot that is wrong, apparently, with the Jordan investigation. But just first off, I mean, what are the implications here? And do you see a potential link between the conversations that are clearly happening between House Republicans and Donald Trump and the documents they are calling for as part of this alleged investigation?
Absolutely. The requests that you read for information from Jordan and his committee are designed to get the prosecution's case file, things that might be in some cases owed to the president in discovery and in other cases not owed in discovery. They want all of it, and then they can do pretty much whatever they want to do with it. And they don't seem terribly interested in negotiating with Alvin Bragg about some narrower set of materials. This does seem to be the real purpose here, is to help the president's defense. And that's, of course, not a permissible purpose.
Yeah, well, that's not what Congress is supposed to be doing.
Nope.
The zeroing in on Carey Dunn and Mark Pomerantz, what does that tell you about their interest in Cy Vance's investigation and the degree to which that very much may be a live issue inside the DA's office?
Yeah, I think they know. Well, for one thing, Pomerantz wrote the book. And so it will be very hard for him to kind of categorically refuse to answer questions. He can't say as easily as the district attorney can that, I can't talk about any of this because he just wrote a book about it. Mm-hmm. And he may well also have indicated, and this is just speculation from the fact that Bragg did not wait for the subpoena to be enforced, but instead affirmatively is trying to quash the subpoena, that perhaps he knows that Pomerantz will show up for his deposition or interview. And therefore, he's trying to get the court to prevent that from happening.
How much, I mean, you make mention of the book, which was not with the approval of the DA's office. It's clear that Alvin Bragg is not happy about the publication of that book. But if you're Trump and you're looking to you're looking to gather your defense for a possible second criminal indictment, maybe, or the one that's already on the table, how much can he get from Mark Pomerantz how much can he get from Pomerantz that's not actually in the book?
If Pomerantz is going to be forced to testify or is willing to testify, the answer is a lot, because he was the person, along with Carrie Dunn, who was running this investigation for at least a year. Although it was much broader than the charges that were brought, it encompassed those charges as well. And so he no doubt knows a tremendous amount of information about the district attorney's concerns about the case, their assessment, the strengths and weaknesses, the internal deliberative process about whether to bring the case or not. So they clearly want him to testify, and this lawsuit seems designed to prevent that.
They're also asking for communications between the DA's office and the DOJ as it pertains to Donald Trump. Now, presumably that's because they're saying this House investigation has to deal with congressional oversight into the use of federal funds, and we want to see what the DOJ is saying to the DA's office. But what could they glean from those communications beyond whether or not federal dollars were used correctly?
Well, we know that the U.S. Attorney's Office in the Southern District did not pursue these charges, to go along with the Southern District's program of admitting to all of his prior wrongdoing, which is part of what the Southern District requires of cooperators. So they are hoping that maybe there is something in those communications that would help Trump. Not evidence, but the assessment of the evidence. Because, of course, exculpatory evidence Donald Trump should get. That's the Constitution, but not the internal chatter by the prosecutors.
Speaking of the Constitution, I mean, so we know what Trump wants. We know what the House Republicans want, presumably on Trump's behalf. What the DA wants is for this all to go away. And on its face, this seems like a violation of the separation of powers, does it not? I am not a lawyer, but there seems to be so much good evidence in the DA's favor as far as how basically this investigation cannot and should not continue. How do you read it?
Yeah, no, in terms of the core question of is there a valid legislative purpose, we certainly haven't seen anything from Jordan that explains what that valid legislative purpose is. You mentioned the idea that there's some connection to federal funds. And while there doesn't need to be much of a valid legislative purpose, the courts have been pretty deferential to Congress. There needs to be something. And we haven't really seen that something yet. There's some procedural hurdles that I think the district attorney will have to encounter. Sovereign immunity claims. There's a clause in the Constitution called the Speech and Debate Clause.
Oh, we're familiar with that on this show. But you go ahead.
No, it gives Congress considerable authority here. But that authority is not unlimited. And so, like so many times we've seen in the Trump era, we're going to make some precedent here, because this is not a frequently litigated thing. Mostly, the person waits until the subpoena is enforced. And of course, we saw that over and over again in the Trump administration.
Yes, we sure did. But I mean, you say we don't know what this investigation is for on the part of House Republicans. I mean, I have my theories, right?
We know.
They have also been pretty explicit, right? And this is cited in D.A. Bragg's complaint. House Speaker Kevin McCarthy tweeting, "The House of Representatives will hold Alvin Bragg and his unprecedented abuse of power to account." Republican Congressman Dan Bishop, who's now on the House Judiciary Committee, tweets, the subpoenas should now fly. And indeed they have. House Oversight Chair James Comer, in an interview with CNN, saying that Bragg should, quote, "come explain to us exactly what he's investigating." Does that matter? I mean, do those tweets, do those explicit statements that we're going to come get you, Alvin Bragg, I mean, does that matter in the context of the judge who is going to be handling this complaint from the DA?
I think they will matter to the judge, because they will show that whatever is advanced, first of all, it's going to have to be more than this for Jordan to go forward with this. But he will be allowed, Jordan, to come up with completely new rationales that are nowhere cited in his prior statements. And the way courts often look at this is they let the legislator essentially have a do-over. So I do think that these statements will discredit whatever they come up with. And to be sure, if all they can come up with is what you've just read, that isn't enough. But it won't be essentially up to the subjective statements by Jordan. The lawyers can now come in and offer some completely new, superficial, pretextual explanation for what they're doing, and that'll be the clash in court.
I mean, I have to say, when you look at this from the long lens of what this establishes in terms of partisan politics, the weaponization of committees and weaponization of subpoena power on Congress, right? These are some of the House Republicans that are issuing these subpoenas, that are meddling in all this, are the same House Republicans who defied subpoenas from their congressional counterparts in the January 6th investigation. And what precedent does that set as far as, how Congress functions when you have taken something like the subpoena and used it for such explicitly partisan goals in this instance?
Well, what is it? The eighth circle of hell was hypocrisy. And this is certainly within that definition of hypocrisy for people to oppose obviously legitimate congressional investigations, such as January 6th, where there's a clear legislative purpose. And then to come forward with this kind of stuff, it's very weak. And as you say, it poses real separation of powers issues. If any district attorney can be forced to turn over their case file essentially to the defendant, it changes dramatically the structure that the framers created.
And what are the implications for example, Fani Willis, the Fulton County DA, who is in the middle of her own investigation? There may be charging decisions next month. Can Congress do the same thing to her?
They certainly will if they're able to get away with it here, and potentially with the DOJ investigation. And there may be even an easier legislative purpose argument to make, congressional oversight of the Department of Justice. But it's totally unprecedented to go into an active investigation for all the reasons that you discussed. Grand jury material, confidential prosecutor files should not be disclosed to Congress to help the defendant.